now proceed with the second reading of the Matrimonial Clauses Amendment Bill 2024, Bill number 10 of 2024, published on the 5th of July of this year. Honorable Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlall S.C.
Good morning, Mr. Speaker and honorable members of the House. Mr. Speaker, the Matrimonial Causes Amendment Bill 2024, Bill number 10 of 2024, is before us for its second reading. Mr. Speaker, from the life of this Parliament, September 2020 to now, we would have brought nearly 100 bills to this House, touching and concerning almost every conceivable area of national life. The intention of all those bills is to impact positively the lives of our people and to ensure that we live in a more modern, regulated society. The bills that we have brought before Mr. various sections and sectors of our population more than others. This bill, the Matrimonial Causes Amendment Bill, and the bill that we will debate later, the Family Violence Bill, are perhaps two bills that will touch the lives of every single Guyanese in a manner so intimate, more than any of the bills that we have brought so far. Mr. Speaker, the Matrimonial Causes Amendment Bill deals with the fundamental institution of the family and marriage. The principal act, the Matrimonial Causes Act, is that law that regulates the institution of marriage and divorce, as well as issues ancillary thereto. And the family being the nucleus upon which our society is built, obviously will impact every single Guyanese. And therefore this bill has far-reaching ramification for the family in Guyana and for every single citizen. And perhaps, if only for the record, I should briefly give an overview of the historical evolution of our matrimonial law. When the Dutch ceded Guyana, British Guyana, to the English supplanted their legal system in Guyana, or upon Guyana. At that time, divorces and family law, matrimonial law, was within the jurisdiction of the ecclesiastical courts of England and were governed by what is called a canon law. Then, I believe, in 1873, they passed the first Matrimonial Causes Act in the United Kingdom and removed the jurisdiction from the ecclesiastical courts and put it within the bosom of the Supreme Court of Judicata. And that was the first movement of our family law from the religious realm into the legal system proper of the United Kingdom. At that time, you had only one ground for the dissolution of marriage, and that was adultery. So to get a divorce, one had to prove before a judge that a party, the other side, committed the terrible offense of adultery. And that was the law. It was sin-based, having evolved from the tenets and canons of the Roman Catholic Church. In 1912, the Royal Commission, the Anglican Church, in 1912, the Royal Commission of the United Kingdom commissioned a review of the matrimonial law of England. And out of that came the 1937 Matrimonial Causes Act of the United Kingdom. It is that act that we received as part of our colonial legacy, and it is that act that up to today forms our matrimonial law. So our Matrimonial Causes Act, Chapter 45:02, is essentially an act that is about 90 years old, and that is the law governing matrimony in Guyana. In that act, there were additional grounds upon which you can dissolve a marriage. So you had added to adultery, cruelty, sodomy, desertion, bestiality. I think those were the exhaustive grounds. So to get a divorce, you had to prove that the respondent was guilty, or is guilty because it's still the law, of one of those wrongs before you get a dissolution of that marriage. And as I said, that position obtains today. The fact that we have a law that is nearly 90 years old governing marriages in Guyana without more makes a case for reform. What societal values were 190 years ago, what family values were 90 years ago, what social realities and legal realities were 90 years ago, are radically different from what they are today. So by a sheer passage of time, this law requires reform. And reform has been done right across the Commonwealth. This act that we have today in Guyana, for example, was repealed in England itself since 1973, 51 years ago. But 51 years hence, we have persisted with it. The other important issue that one must recognize also is that the relationship between the two genders have changed drastically. In 90 years ago, there was no equality between man and woman. I am hearing that there is still not yet, but I'm speaking from the position of a constitution, which is the supreme law of our country, that guarantees equality of sexes, equality of treatment, and the freedom from discrimination on the basis of gender, race, sex, etc. So, in our matrimonial law, there are several areas, several provisions in which you do not have equal treatment and equal facilities extended to the different genders, to the husband and to the wife. So that needs to be addressed. And it came to fore in a matter which was filed recently in the High Court of our country, where a man challenged a particular provision, a husband, of the Matrimonial Causes Act that only permitted a wife to seek alimony upon the dissolution of the marriage. And the man invoking Article 149 of the Constitution, which protects every citizen of Guyana against discriminatory treatment on the basis of gender, race, religion, sex, etc., argued that, look, this thing is discriminatory. My wife can seek alimony against me, but I cannot reciprocate. The Attorney General was the respondent in the case, because the argument was that the provision in the Matrimonial Causes Act collided with the equal treatment provision in the Constitution and the discriminatory provision in the Constitution. And I conceded that the act indeed was offensive to the different provisions of the Constitution that speak to equality of treatment. And we gave an undertaking that we will come to the Parliament to correct that unconstitutionality. In any event, the learned Chief Justice presiding in the case struck the provision down as being unconstitutional. And then there is, as I articulated earlier, the fault-based system in our divorce law. Now, as I said, in our divorce law, you have to prove that the other side committed or is guilty of one of the wrongs that constitute the grounds upon which a divorce can be granted. If you cannot establish that, then your petition for a divorce fails, and whether you and the husband or you and the wife have had an intolerable relationship, whether you have had an irretrievable breakdown, you remain married to that person because you are unable to prove to the satisfaction of the court of competent jurisdiction that your partner is guilty of one of those grounds. And when I get into the bill, I will go through those grounds. That has led to untold social damage and has forced parties to, in order to establish one of these grounds to the satisfaction of a court, publish a lot of things that ought not to be in the public domain about the other side. Bedroom matters, highly personal matters, embarrassing matters, and most importantly, matters that will cause and that have caused further destruction to an already strained relationship. Who are in you more particularly because they have children, for example, and they need to still parent those children, or they have matrimonial assets that they have to civilly sit down and share in accordance with the law, or divide in accordance with the law, having regard, most importantly, to the future welfare of the children. So you have two persons who are pitted against each other in a highly adversarial environment, forced by provisions of the law to say the nastiest things about each other and engaging in protracted litigation, lasting years sometimes, and at the same time are expected to civilly deal with the children issues, maintenance, children education, etc. You and I know that what happens in those circumstances. There is an African proverb that says, when the elephants fight, the grass is destroyed. So when the two parents fight, most of the times, the children suffer the consequence. Recognizing that you can't keep two parties, two human beings who enjoy autonomy, who enjoy the freedom to choose, locked in matrimony against their will because they may be unable to prove to the satisfaction of a court a particular grounds for a divorce that is 100 years old. Societies in the Commonwealth, in the United States, in England, and across the Caribbean have moved into a different direction. And they have said, they have formulated and insert in their law that if two parties can't live together anymore, if their marriage suffers an irretrievable breakdown, or the marriage is irredeemable or irremediable, broken down, then what is the sense of keeping the two people chained legally together in matrimony? So they have allowed parties to go their separate ways with the acceptance of the fact that they have been unable to live together. And the truth of the matter is, in many cases in Guyana, that has been the practice already. So persons have been forced, essentially, to perjure themselves in order to get a divorce. One side agreeing not to contest, and all sorts of backdoor deal have been entered into in order to get a smooth, non-contentious, and civil dissolution of the marriage for the benefit of all. This bill changes that. We tried years ago to do it, but there were some resistance from some segments of our population. This time around, consultations were held, and I believe those segments of the population that felt strongly about this matter have now changed their view. So that's another wave of amendments that we bring in this bill. And there is another section also in the law, another concept rather, in our law that has been overtaken by legal and social reality. And it is the ancient concept of restitution of conjugal rights. So if you and your wife are estranged, you don't want a divorce, you can approach a court now and get an order directing your wife to come back into the home. By order of court. So you are forcing a person to live, to cohabit with a person whom they don't wish to cohabit with. The law of rape has developed and advanced so far that it is possible for a man to rape his wife. Well, I don't know about vice versa. Well, I don't know. I will say man raping his wife, because rape still has a definition of penetration. Entry. So the You now have a position where you can get a judge making an order to allow forced sexual relations. And as I said, that constitutes rape, or that constitutes some form of sexual violence. That is completely out of sync with current social and legal realities. That is another wave of amendments that this bill seeks to introduce. The bill also amplifies the grounds that a court must take into account when examining the issue of maintenance and when to grant maintenance and the type of orders that a court can make when treating with alimony and maintenance. So the bill, as I said in that overview, has some very wide-ranging changes with deep and far-reaching ramifications. So Clause 2 of the bill introduces a definition section which was not in the original, which is not in the Principal Act. And why a definition section is needed is because of the changes that have taken place over the years in the law of matrimony and in the law of family. So we had to define who is a spouse, because a spouse now, in 1937, 90 years ago, a spouse could only have been a legal spouse because you had no common law relationship recognized by the law at that time. So when the Matrimonial Causes Act speaks about a spouse, and if we were to continue using the term spouse, it can lead to ambiguity. So we put a definition of spouse to differentiate it from a common law union spouse, which is also recognized under a different legislation. So spouse means, at Clause 2, a man and a woman who are married to each other and which marriage is registered under the Marriage Act. So we have to be very specific, because you can marry in common law under religious rights, you can do the nikah, and you can live for 5 years, and you really, for all intent and purposes, you have become a legally married wife with all the powers and privileges enjoyed by a legally married person in the traditional sense. The same thing can be said of marrying under the Hindu religious rites of the Maro. But once you take that ceremony now and you register it under the Marriage Persons Act, under the Marriage Act, that is when it becomes a legal marriage for the purpose of the Matrimonial Causes Act. Because here is now where you can get the divorce. Under the common law union, though your union is recognized and you can get all the rights of a married woman or a married man, you don't have to dissolve that because it was never solemnized under the Marriage Act. So we are drawing that distinction in the definition section. We have also defined marriage to include a void marriage. And this is where you can enter into a ceremony of marriage, register it under the Marriage Act, but not knowing at the time that it is void. So you can Honorable Member Annette Ferguson, you can marry your loved one, not knowing that he was married at the same time to someone else. That marriage, when you recognize that he was married before, becomes a void marriage. But it is still recognized under this act because you will not be deprived of what you would have been entitled to had the marriage been lawful. And when you remarry now, you may use the term remarry. Since your earlier marriage was void, this new marriage now will be your first marriage. So the definition section takes care of those eventualities. Clause 3 of the bill, as I said, abolishes the restitution of conjugal rights. And I explained the reason for the abolition. So that's no longer part of our law. It is outmoded and it has been removed from the books right across at least every country that I've looked at. So we have removed that. And clause 3 also deals with, there's another concept called judicial separation, which we have retained. So short of a divorce, you can go to a judge and get an order for judicial separation. It's hardly ever used, but it's still in the statute books, and we did not see any harm in keeping it there. But what we have done is that the same grounds upon which you can get your marriage dissolved, cruelty, desertion, bestiality, sodomy, adultery, etc., those are the same grounds that you can get judicial separation on. What we have done, since we have added a new ground to divorce, which I'll speak to later, we have added a new ground correspondingly to judicial separation. So that's what clause 3 does. Clause 4, as I said, there are a series of provisions that are in the bill which change the relationship between husband and wife in the act to put them on equal footing. Because there are a series of provisions in the principal act that confers protection upon a wife, but does not reciprocally confer such protection on the husband. So in those provisions, we have brought equality and equilibrium. So clause 4 is one of them. In the eventuality of a particular situation, the wife's property was offered protection only. We have extended that protection to the husband's properties as well. Clause 5, again, there were orders that one can get under judicial separation, but that one can get, only the wife could have gotten. We have now extended them to apply to the husband. Clause 6 provides for payment of alimony to the wife or the wife trustee. Again, we have made that applicable to the husband. 7, same type of equal treatment being inserted to ensure that the wife and the husband are on same footing. Clause 8 is the same thing. Clause 9 is where the bill speaks to, or the principal act speaks to, the dissolution of the marriage. And perhaps, as this is one of the pivotal issues in the bill, I might as well read clause 9 in its entirety. A petition for divorce may be presented to the court either by the husband or the wife on the ground that the respondent has since the celebration of the marriage been guilty of adultery or malicious desertion with or without adultery. B, that the respondent has since the celebration of the marriage treated the petitioner with cruelty. Or C, that the respondent is incurably of unsound mind and has been continuously under the care and treatment for a period of at least 5 years immediately preceding the presentation of the petition, and by the wife on the ground that her husband has since the celebration of the marriage been guilty of rape, sodomy, or bestiality on the part of the wife, of irreconcilable, and then we are adding this, of irreconcilable differences which has caused the irremediable breakdown of the marriage. So you can either prove those grounds, we are not taking away those grounds. Anyone who wishes to go to court and go the traditional method of proving fault, they have the right and the freedom to do so. But those who wish not to travel that road that has been so arduous as established by experience can now go on the ground that you have an irretrievable breakdown of the marriage due to irreconcilable differences. And it gives you the right and the freedom not to detail what they are. So you don't have to give all the gory details. The two parties go before a judge and they say, Your Honor, this marriage can't work. We have irreconcilable differences. This marriage has broken down. And we want to move on with our separate lives. That is what this allows to take place now. Subject to one caveat. And that caveat is that the parties must establish to the satisfaction of the court that they have been living separate and apart for at least 6 months before the presentation of the petition. Why? Because you want an opportunity to see whether there can be a reconciliation. So the parties can have that period. Then one can also argue that this 6 months shows the court that this is not a collusion between the two parties, that there is actually a separation and they have not been living together as man and wife for at least 6 months immediately prior to the presentation of the petition. And we have not left it there. We have now proceeded to explain further by inserting immediately this subsection. The parties to a marriage may be held to have separated, so that 6 months period can constitute separation, notwithstanding that cohabitation was brought to an end by the action or conduct of only one of the parties. So, one of the parties not cohabiting, that is sufficient. And then the other part of it reads, the parties to a marriage may be held to have separated and to have lived separately and apart, notwithstanding that they have continued to reside in the same residence or that either party has rendered some household services to the other. So practically, persons have been forced to continue in an unhappy matrimonial relationship simply because they don't have anywhere else to go. And as a result, they are forced to live in all sorts of conditions. This provision allows the parties who may not be able to move out to prove separation, because remember, you have to show separations 6 months prior to the presentation of the petition. So if you don't have anywhere to go, you can stay in the house. The two parties can live under the same roof, but live separate and apart. And you can still continue to have a civil relationship. If it is that you want to continue cooking for the man because he's not your enemy, as I said, this whole provision is to ensure that there is a harmonious relationship after the divorce. So it conduces to the parties, though cohabitation may end, though marital relations may end, to continue to perform particular household chores or household services as the parties may determine between themselves. As I said, it is intended to ensure that there is affection and there is not wrath and anger and hostility permeating the relationship, because that is not what we want between a husband and wife after their marriage ends. We want them to continue to live, at least in civility. Clause 10 amends Section 14 of the Principal Act. And this is the section that I spoke about, which was the subject of review by the High Court recently. And it now provides for either the husband or the wife to receive maintenance or alimony after the divorce. And the clause sets out in great details the factors that a court ought to take into account in determining quantum, etc. If I may share it briefly with you. In determining the quantum of maintenance a party to the marriage may be entitled under this section, in determining the quantum of maintenance a party to the marriage may be entitled to under this section, the court shall have consideration of the following matters only: age, state of health of the parties, income, property, financial resource, physical, mental capacity of each of them, gainful employment, whether the party has care and custody of a child of the marriage, the financial needs and obligation of each parties, and there's a whole long list of over 12 factors that the court is free to take into account in determining the appropriate quantum. And then it also deals with the type of orders that can be made, so that the court has a power to make lump sum payment by monthly, weekly, or any other periodic installment, and a whole host of other types of orders that the court can make in the interest of justice that the case may require. And the other orders, the other section, 14B, for example, deals with the cessation of those orders. You know, maintenance is a personal thing. A husband is entitled to maintain a wife, for example, for the rest of his or her life, not beyond. That's correct. So your beneficiaries are not entitled to the proceeds of a maintenance order. And on the other hand, if the person who is directed to make the order dies, then that person's personal representative may be compelled to continue making the maintenance order because the wife is still alive or the husband is still alive. And those are debts that flow from the estate. So not because you die means that you have to stop paying. If the beneficiary of the order is alive, and if the order is for the remainder of that person's life, then your personal representatives will have to continue making payment. Different considerations will also apply if the person remarries, because you're not supposed to pay maintenance after the person remarries, unless, of course, there are exceptional circumstances that will require the payment of orders in those cases. And then, Mr. Speaker, we have certain consequential amendments because we had to amend certain acts that requires application for maintenance, etc., in the High Court and in the Magistrates Court. Those amendments have been made. They are consequential, they are ancillary, and therefore I will not go address them. So, Mr. Speaker, that in a nutshell are the merits of the amendments that are before the court, before the Parliament, the National Assembly, and I ask that we support it. Thank you very much.